finishing up on the Sebelius case, while the majority said that this is okay under the taxing power, there were some concurrences and dissents. Judge Robert wrote a separate opinion saying that this isn't okay and it's not okay under the Commerce Clause because this is economic inactivity. So this is Congress saying you have to buy something. And we've never had a case before where Congress is allowed to tell people they have to buy things. Normally, the Commerce Clause is more indirect, right? To help make sure commerce is functioning, to keep those channels free, to stop monopolies, to make sure that people can spend money. But we've never had a situation where Congress said you have to buy something before. So Justice Roberts' separate opinion, he wrote just for himself, so it's not the controlling opinion, says that Congress can't regulate economic inactivity, like not doing something, can't get you in trouble because you don't buy enough. They can only regulate activity once people are buying things. Justice Ginsburg concurred in part and dissented in part because she thinks that this is okay under the Commerce Clause because people not having insurance does cost billions of dollars a year for the healthcare industry, and it costs billions of dollars in emergency room equipment, and those goods are all produced and sold and delivered, across state lines, and that people who aren't insured cross state lines to get insurance in other countries. So she thought there is enough under the Commerce Clause here. And there was a dissent by Justices Scalia, Kennedy, Thomas, and Alito, who said that the individual mandate is unconstitutional because it's the Commerce Clause, and that, again, this is the type of commerce that they've said they're not going to allow, starting in Lopez versus Morrison. And very lastly, Justice Thomas wrote a dissent, and in that he discussed how this isn't okay, it should be unconstitutional. If you look at the original understanding of Congress's powers and the early Commerce Clause cases, and he wanted to go back to the early cases where you can just regulate channels and things in interstate commerce. So what happened now is that in 2017, Congress passed a law called the Tax Cuts and Jobs Act of 2017. And what they did was they reduced the penalty to $0. There wasn't enough support in Congress to be able to repeal Obamacare, as people may remember, but there was enough support to make that penalty be $0. So now if you don't buy health insurance, your penalty is $0 on your taxes. So now the case is back before the Supreme Court, because since there is no tax penalty, and since the Supreme Court in Sebelius said it was okay because it was a tax power, a case came up again saying, okay, well now it's unconstitutional because there's no taxing. And the Supreme Court heard that case this term. They heard arguments in it, and we're expecting a decision sometime soon. And we don't know what way it's going to go. And so that's where we are. And it looks like now you can see my live coronavirus update. It wasn't going to be heard until next term, actually. And now we're not even entirely sure how this is going to go. Basically, the takeaway is 1937 to 1995, Congress could do whatever it wanted under the Commerce Clause. In the 90s, that changed. Maybe in the 2000s, they're letting Congress do more under the Commerce Clause, but we really don't know. There's going to be a quiz in the comments to this video below, so make sure that you do it, and it's going to cover all the Commerce Clause videos. See you all soon.